Every single day, millions of retired Americans wake up and do the same mental calculation. They check their bank account, they look at what came in from Social Security, and they figure out whether this month they can afford their medication and their groceries at the same time. That is not a hypothetical situation. That is the lived reality of tens of millions of people who spent 30, 40, sometimes 50 years working, paying into a system, and trusting that the system would hold up its end of the bargain when the time came. Today, we are talking about something that directly affects every single one of those people. Something that happened inside the highest court in this country that most people have not heard about yet. And by the time this video is over, you are going to understand exactly why this matters to you, to your spouse, to your parents, and to anyone you know who is either retired or getting close to it. Stay with me from the very beginning to the very end because every part of what follows is important. 9 justices, complete agreement, and every single retired person across all 50 states is about to feel the effects of what just took place inside the nation's highest court. This is not a partisan story. This is not a conservative versus liberal debate. This is a unanimous decision, meaning the most right-leaning justices and the most left-leaning justices sat together, reviewed the same evidence, studied the same legislation, and came out on the other side in total agreement. That almost never happens in a court that has been this divided for so many decades. A 9-0 ruling is not just uncommon, it is historic. What the Supreme Court just decided reaches directly into the retirement security of millions of Americans who spent their entire working lives contributing to a system they were assured would be there for them. We are talking about Social Security benefits. The money that older Americans count on every single month to pay rent, buy groceries, cover prescriptions, and keep the lights on. This ruling changes the legal framework around how that money is protected, how it can be reduced, delayed, or denied, and what rights you now have if the government attempts to interfere with what you are owed. Before this ruling, there was a quiet but serious pattern developing inside federal agencies that most retirees were never aware of. Administrative decisions were being made about Social Security benefits with almost no meaningful way for ordinary Americans to push back on them. The appeals process was slow. The outcomes were often predetermined. Retirees who had been wrongfully denied benefits or had seen their monthly payments reduced without clear explanation found themselves stuck inside a system that seemed designed to exhaust them into giving up. And many of them did give up because fighting a federal agency when you are living on a fixed income, when every month matters, when legal costs alone can drain your savings, is not a fight most people have the energy or resources to take on. That was the reality before this ruling came down. And here's where the story of one ordinary American changed everything for every retired person in this country. There was a retiree who had worked for decades, contributed to Social Security throughout his entire career, and reached retirement age expecting to receive exactly what he had been promised. Instead, the agency responsible for managing his benefits made a series of administrative decisions that reduced what he was rightfully owed. He challenged those decisions. He went through the internal appeals process exactly as required. He followed every rule, filed every form, met every deadline. And at every stage, the agency used its own interpretation of its own regulations to rule against him. The system was essentially grading its own work and awarding itself a perfect score every time. So he took the matter to federal court. And then it climbed higher and higher until it reached the Supreme Court of the United States. When those 9 justices examined what had happened to this man, when they looked at how federal agencies had been operating with nearly unchecked authority to interpret the laws governing Social Security benefits in whatever way served the agency rather than the retiree, they did not split 5-4 the way most people expected. They did not divide along ideological lines the way nearly every other major ruling does. They agreed, all 9, unanimously. The foundation of what the Supreme Court decided comes down to a principle that sounds almost too straightforward to be the center of a landmark ruling. Federal agencies do not get to be the final authority on what the law means when it comes to the benefits you are legally entitled to receive. For decades, something known as the Chevron Doctrine had granted federal agencies enormous power to interpret the laws they administered. What that meant in practice was that whenever there was any ambiguity in a law related to Social Security, the agency running that program got to decide what the unclear language meant. And courts were told to defer to that agency interpretation as long as it appeared reasonable, not whether it was accurate, not whether it was fair to the retiree, simply whether it seemed reasonable to the people inside the agency making the call. Think about what that actually means. Imagine you have a legal contract that says someone owes you money every single month for the rest of your life. And then imagine that whenever there is any disagreement about what that contract means, the other party gets to serve as the judge. They interpret every unclear phrase. They decide every close question. And the court is told to go along with whatever they conclude unless it is entirely unreasonable. That is what retired Americans were living with before this ruling. That is the system that was in place while millions of people tried to fight for benefits they had earned over a lifetime of work. The Supreme Court examined that arrangement and said it could not stand. Courts are supposed to determine what the law says. That has always been their responsibility, going back to the earliest foundations of American constitutional law. When a federal agency makes a decision that takes money away from a retiree, reduces their monthly payment, or denies their claim, and that retiree challenges it in court, a judge must now apply genuine independent legal analysis. Not automatically validate what the agency decided, not defer simply because the agency has experience running the program, but actually read the law, determine what it means, and protect the rights of the American citizen standing before that court asking for what they were promised. That is the shift. That is what a 9-0 ruling looks like when it lands in the real world of retirement security. If you are currently receiving Social Security benefits, or if you are within 10 years of retirement, or if you have a spouse or a parent who depends on those monthly payments, this ruling is not an abstract legal development happening somewhere far from your daily life. This is the foundation of your financial security being rebuilt on stronger ground than it has stood on in many decades. Here is something most coverage of this ruling is missing entirely. The impact is not identical in every state. Because Social Security Administration involves both federal regulations and state-level implementation in certain programs, the practical effect of this ruling on your specific situation depends partly on where you live. Some states have been more aggressive than others in using administrative interpretation to limit certain categories of benefits. Some states have larger backlogs of denied claims sitting in the appeal system right now. Claims that were decided under the old framework where agencies held all interpretive power. Those pending cases are now being viewed through a completely different legal lens. In those states, the number of retirees who may now have legitimate grounds to reopen their cases, to challenge past decisions, to demand that a court actually examine whether the agency applied the law correctly, is significant. This is not a promise that every denied claim will be reversed. This is not a guarantee that every retiree who was shortchanged will automatically be made whole. What it is the opening of a legal door that was firmly shut for a very long time, a door that stands between ordinary Americans and the retirement security they spent their working lives building. And the Supreme Court just propped it open with a unanimous ruling that no future administration, no agency director, and no federal bureaucrat can simply disregard. Now let us get into the specific details, the states most directly affected, the categories of Social Security benefits where this ruling carries the most immediate impact, and what options now exist for retirees who were denied, reduced, or delayed benefits under the previous framework. Start with the states that carry the highest volume of Social Security disability and retirement benefit disputes currently sitting inside the appeal system. States like Florida, Texas, California, Pennsylvania, Ohio, Michigan, Georgia, and Illinois have enormous retiree populations. Tens of thousands of benefit claims have been denied, reduced, or delayed in these states over the past several years. Many of those decisions were made by administrative law judges operating inside the Social Security Administration itself. Under the old Chevron framework, when those decisions were challenged in federal court, judges were instructed to give significant deference to how the agency interpreted its own rules. That deference is now eliminated. Every pending challenge and every new challenge filed going forward will now be evaluated by a federal judge who is required to make an independent determination about what the law actually says and whether the agency applied it correctly. That is not a minor shift. That is a fundamental rebalancing of power between the federal government and the American retiree. Now, let us talk about the specific categories of benefits where this ruling has the sharpest and most direct impact. The first is Social Security Disability Insurance, known as SSDI. The denial rate for initial SSDI applications has been extremely high for years. A significant portion of those denials come down to how the agency interprets the medical and functional criteria written into the law. Those interpretations have historically been given enormous deference by courts. That deference is now removed. If you were denied SSDI benefits and you believe the agency misread the legal standard that applies to your medical condition or your functional limitations, you now have stronger legal standing to pursue that challenge in federal court than you have had at any point in recent memory. The second category is survivor benefits. When a spouse passes away, the surviving partner is entitled to certain Social Security survivor benefits based on the deceased spouse's earnings record. The rules governing these benefits are written in federal statute, but for years, the agency has had broad latitude to interpret edge cases, particularly around marriage duration, timing of claims, and coordination with other benefit programs. Under the new framework established by this unanimous ruling, those interpretations are no longer automatically protected from judicial review. If a surviving spouse was told their benefit amount was calculated a certain way because of the agency's interpretation of an ambiguous provision, a court can now examine that independently and reach its own conclusion about whether the agency was correct. The third category is retirement benefit timing and reduction rules. There are complex provisions in Social Security law that govern how benefits are reduced when someone claims early, how benefits interact with pension income in certain cases, and how benefits are calculated when someone has worked in positions not covered by Social Security for part of their career. These provisions have generated enormous administrative interpretation over the years. Some of those interpretations have cost retirees thousands of dollars annually. With the Chevron deference framework now dismantled, challenges to those interpretations stand on fundamentally different legal ground than they did before this ruling. Here is the part of this story that most coverage is completely overlooking, and it connects directly to the long-term financial security of everyone watching right now. This ruling does not only affect people who are currently in a dispute with the Social Security Administration. It transforms the environment in which every future benefit decision will be made. Agency officials and administrative law judges inside the Social Security system now understand that their interpretations of the law are subject to genuine independent judicial review. That awareness alone changes behavior. When decision makers inside a bureaucracy know that a federal judge will actually scrutinize their work rather than simply defer to it, the quality and fairness of those decisions tends to improve. The accountability this ruling creates is not just legal, it is institutional. It reaches into the culture of how these agencies operate on a daily basis. Think about what this means for someone who is currently 55 years old and planning to retire within the next decade. The decisions the Social Security Administration will make about your benefit amount, your eligibility, and your claiming options will now be made inside a system where independent judicial oversight is real and meaningful. The agency cannot simply adopt the interpretation most convenient for its administrative purposes and rely on courts to approve it without question. Now, let us address a misconception that spreads quickly whenever a ruling like this comes down. Some people hear about a Supreme Court decision that limits agency authority and immediately assume it means the government is about to reduce Social Security benefits or cut program funding. That is not what this ruling does. This ruling does not reduce any benefit. It does not authorize any cuts. It does not give Congress or any administration new power to shrink the program. What it does is the opposite. It gives individual retirees stronger legal standing to challenge decisions they believe are wrong. It transfers interpretive authority away from the agency and toward courts that are constitutionally designed to be independent. For retirees, this is a protection, not a threat. There is also a practical question many retirees and those approaching retirement are asking right now, and it deserves a straightforward answer. If you had a benefit claim denied or reduced in the past, does this ruling give you a path to reopen that case? The honest answer is that it depends on where your case stands procedurally and how much time has passed since the decision was made. Federal law has specific deadlines for challenging agency decisions, and those deadlines do not disappear because of a new Supreme Court ruling. What this ruling does is change the legal standard that applies to challenges currently pending and to new challenges filed going forward. For older cases, the path back is narrower but not necessarily closed. There are legal mechanisms, including motions based on changed legal circumstances, that attorneys who specialize in Social Security law are actively exploring right now on behalf of clients whose cases were decided under the previous framework. And here's something worth sitting with for a moment. The attorneys and legal advocates who work exclusively in the Social Security space are not treating this ruling as just another procedural update. They are treating it as a turning point. Many of them have spent years watching clients lose cases, not because the law was against them, but because the agency's interpretation of the law was treated as untouchable. That dynamic has now changed in a way that is fundamental and lasting. Legal professionals who represent retirees in benefit disputes have a genuinely different set of tools available to them today than they had before this ruling came down. And for the retirees sitting across the table from those attorneys, that difference is real and it is meaningful. It is also worth understanding what this ruling signals about the broader relationship between American citizens and the federal bureaucracy. For generations, the assumption inside Washington has been that agencies are the experts, that they understand the regulations better than anyone else, and that courts should largely stay out of the way and let them operate. The Supreme Court just unanimously rejected that assumption in the context of Social Security, and the message extends beyond just one program. It is a signal that the era of unchecked administrative interpretation, at least when it comes to the financial benefits that ordinary Americans depend on, is over. Courts will now be doing the job they were always constitutionally intended to do: reading the law, applying it independently, and standing between citizens and government overreach when the law requires it. For anyone watching this who has felt helpless in the face of a Social Security decision that felt wrong, that felt unfair, that reduced your income or denied your claim without what seemed like a legitimate reason, the most important thing to take away from this video is this: the legal landscape has changed, the standard has shifted, and the system that once seemed designed to wear you down now has a layer of independent oversight that did not exist before. That is not a small thing. That is the difference between a system that works for the people it is supposed to serve and one that simply works for itself. What does all of this mean when you bring it back to the most important number in this entire story, 9-0? Every justice on a court that has been bitterly divided on nearly every major question for years looked at whether federal agencies should have unchecked authority to interpret the laws governing your retirement security and said no, unanimously. Without a single dissent, without a single reservation significant enough to produce even a partial disagreement. The strength of that consensus is itself a message to every federal agency, every administrative law judge, every official making decisions about the benefits of retired Americans. The message is that the courts are watching, that the law means what it says, and what it says will now be determined by judges who are accountable to the Constitution, not by agencies that are accountable primarily to their own administrative convenience. If you have been contributing to Social Security your entire working life, if you are planning a retirement that depends on receiving what you were promised, if you have a parent or a spouse whose monthly benefit payment is the difference between stability and hardship, this ruling is the most significant legal development in the retirement security space in an entire generation. If this video gave you information you did not have before, do one thing right now. Share it with someone who needs to hear it. A parent, a spouse, a friend who is approaching retirement and has no idea this ruling even happened. Drop a comment below and tell us which state you are in and whether you or someone close to you has ever dealt with a Social Security benefit dispute. Every comment gets read, and the conversation in the comment section of this video matters. And if you want the follow-up breakdown covering exactly how this ruling applies state by state and what specific steps retirees can take right now, make sure you are subscribed and have notifications turned on because that video is already being put together and you do not want to miss it. 9 justices, 0 disagreement, 50 states affected, and a retirement system that just received a stronger constitutional foundation than it has had in decades. You came here for information that actually matters. And now you have it.